How y'all feel out there? Do you feel good? I said, do you feel good? Come on.
The groove feel good when it make you move. Make your next move your best move. I said the groove feel good when it make you move. Make your next move your best move. It feel good, don't it? It feel good. It feel good cause you know it's good. Hey, it feel good, don't it? It feel good. It feel good cause you know it's good.
What's up, good people? Safari Tourist here again, bringing you the after soda information absolutely free. Welcome to Safari Tourist channel. Please like, share, and subscribe to our channel. And if you've done so, we appreciate you. So today we're going to talk about the K-1 visa, or the Fiance visa application denier. So what precepts that sets the precedent for denial of the K-1 Fiance visa? We'll discuss two stages under which the circumstances surrounding the denial happens. The first stage will happen when the initial or the principal applicant files or petitions Form I-129F in the United States. Who's that? Either a lawful permanent resident or a green card holder or a United States citizen. And the second stage, of course, we'll discuss the circumstances that surround the visa denier on the second stage, after USCIS, through the residence embassy, denies or rejects the visa application. So, disclaimer, our videos are for educational and entertainment purposes only. The sole discretion you make out of our videos is solely on you. We are no legal, immigrational, or financial experts. So let's continue. Let's see the first stage of K-1 visa denial. Number one, either a lawful permanent resident or a United States citizen fails to meet the requirements. What do I mean? Either they do not merit beyond the public charge, or they do not make enough money that they can sustain you in the United States as a fiancé. Number two, the next point under which the visa can be denied will be once USCIS realizes that the previous marriage was not legally terminated. So if you married and you separated, you cannot bring another fiancé for marriage. You remember you have a period of 90 days for marriage to take place in the United States. Therefore, make sure your separation is gone beyond divorce and you have your divorce decree before you start this application. The third point is when the petitioner, that is the green card holder or the United States citizen, they cannot prove beyond reasonable doubt that they have at least met once in 2 years' time. So you cannot petition for somebody you have not seen or you have not met at least once in 2 years. So if your fiancé is in South Africa, or in Kenya, or in Ghana, or in Tunisia, or in Ukraine, or in the United Kingdom, or in Canada or Mexico, make sure at least you've met once in a span of 2 years. Because you cannot petition for somebody you have not seen, maybe you've met online. And lastly, if the petitioner has domestic violence issues, the fiancé visa can be rejected on those grounds. That's it for first stage, my good people. Please remember to subscribe to this channel as I bring you this after story information absolutely free. So let's go to the second stage. The second stage happens when the file has moved from the USCIS to the resident embassy. The beneficiary now, who's your fiancé. So when they go to the embassy, they can be denied the visa if there is a misrepresentation of facts or fraud or omission of a fact. So if they do not put their things, their record or biodata straight, they can be denied a visa. Number 2, still, if the applicant does not merit beyond the public charge, can affect the other party. Also, because if you do not have or you do not make enough that can sustain you in the United States. Number 3, failure to pass medical exams. Let's say you have these kind of diseases like gonorrhea, syphilis, or tuberculosis. You can be denied a visa on those grounds. Or you have maybe a highly infectious disease that is categorized by the public health. Then you can be denied a visa on those grounds. As well, if you're an alcoholic or a drug addict, you can be denied a fiancé visa. The other point, the fourth one, is if you have a criminal record that has not been expunged, then you can be denied a visa. And lastly, if you are unable to be interviewed before the Form I-129 expires, remember this form takes a period, a max of 4 months.